This video is made for educational purposes only and cannot be taken as legal advice. You will find a link to the full judgment in the description. In the Court of Appeal, Criminal Division. On appeal from the Crown Court at Northampton. His Honour Judge Mayo. Before the Lord Burnet of Malden. Lord Chief Justice of England and Wales. Mr. Justice Sweeney. And Mrs. Justice Heather Williams. The 7th of April 2022. The defendant was a plainclothes police officer. He had been issued with a PAVA, pelargonic acid vanillilamide, incapacitant spray, which he kept in the boot of his car when he had finished his duties, contrary to instruction. At the end of his shift he drove home and stopped to buy some petrol. He observed a dispute between a member of staff and a customer who the defendant believed, quite wrongly, to be attempting to make off without paying. He shouted at the customer who refused to engage with him, so the defendant retrieved the PAVA spray and sprayed the customer with it. A police officer called to the scene observed the incident, which was also captured on CCTV. The defendant was charged with possession of a prohibited weapon, contrary to Section 5(1)(b) of the Firearms Act 1968. At his trial, following a ruling by the judge that the provision applied to the circumstances of the defendant's admitted possession of the PAVA incapacitant spray at the relevant time, the defendant pleaded guilty to that offence. He appealed against conviction on the grounds that, although he accepted that he had the PAVA spray in his possession without authority and that it fell within the definition in Section 5(1) of the 1968 Act, it was a well-established rule of statutory interpretation that the Crown was not bound by legislation, absent express words or necessary implication to the contrary. That rule applied to the 1968 Act. The Crown's exemption was extended by Section 54(3)(a) to members of a police force without any limitation placed upon the circumstances in which it applied to them. It therefore followed that, as a police officer, the defendant was exempt from the offence of possessing a prohibited weapon irrespective of the capacity in which he was acting at the time and irrespective of where it came from. The defendant submitted that all Crown servants and those deemed to be so by Section 54(3) were not subject to these penal provisions, even when they were not acting as Crown servants or as one of those identified in Section 54(3) of the 1968 Act. The same argument would apply to other parts of the statute not mentioned in Section 54(1), including Sections 3, 4, 4a, 16, 16a, 17, 18, 19, 20 and much else. Held, appeal dismissed. If the defendant's submissions were correct, not only would, for example, all servicemen and ministers of the Crown be at liberty always to carry arms, as would all those identified in subsection 3, but they could with impunity do the other things with weapons criminalized by the 1968 Act. That submission could not be accepted. Acts of the Crown encompassed the acts of Crown servants, but acts of Crown servants that fell within this rule of statutory interpretation were those undertaken in their capacity as Crown servants. There would be no sensible rationale for the exemption to extend to the activities of Crown servants in their personal lives. The effect of Section 54 of the 1968 Act was to bring persons in the service of Her Majesty acting in their capacity as such within the scope of the specified provisions of the 1968 Act, modified as identified in subsection 2, in circumstances where that would not otherwise be the case. The use of the word apply in the subsection should be noted because it indicated a positive extension of the reach of the 1968 Act, rather than a disapplication. Moreover, the wording of subsection 3 provided that for the purposes of this section and of any rule of law whereby any provisions of this Act does not bind the Crown police officers and others were deemed to be Crown servants, that demonstrated that there were provisions of the Act which did not bind Crown servants when acting as such. Section 54(3)(a) of the 1968 Act extended the scope of those who were to be considered as a Crown servant for the purposes of the Crown's exemption from statutory provisions. It did not modify the rule of statutory interpretation itself. That rule only extended to Crown servants acting in that capacity. Section 54 3a. Exempted a police officer from the provisions of Section 5 of the 1968 Act only if the officer was acting officially as such at the relevant time. That would be a question of fact. Accordingly, in the circumstances, there could be no doubt that the defendant was acting outside his official capacity in having a police-issued pepper spray in the boot of his personal motor vehicle. Section 54 of the 1968 Act provided him with no assistance in those circumstances. He was properly convicted on his guilty plea of the offence of possession of a prohibited weapon contrary to Section 5, 1b, paras 13, 16, 19, 21, 22, 24.